Yeah, good afternoon all. So let's start with the new chapter, Fundamental Rights, Part 3 of the Constitution, Article 12 to Article 35. And before this, as I said, first we need to understand the brief idea about so just copy this. This is the basic one. What do you mean by right? Then we'll go to different types of rights. As I said, natural rights, then human rights, constitutional right, fundamental right, legal right, claims of individuals or citizens against the state, entitlement of an individual. Those are the two. Some people tell they're inherent also, some people tell obligation of the state to provide it, some people tell it's not an obligation. So there are so many things, but these are the most two. Remember, mostly these two. This, that is arguable, as obviously if you have optionals, when you are optionals, you want to study, every thinker will have its own opinion. That's all different. Here we'll study mostly from the constitution perspective. In the beginning, we'll have to understand the concept first, then the constitution. Article 12, what does it say? 13, what does it say? Till 35. Yeah. So that is the basic definition of right. That means claim of an individual or citizen against the state. So claim means what? If first is it's an entitlement, means it's given to you. They can't take it away from you. If in case they take it, so then what you can do? There will be an opportunity, there will be an option where you can go ask for it and it will be given it back to you. If in case an option. That's what technically now today we call it as, they are justiciable in nature. Fine, that all will come to that. So remember in one, where I think in preamble we discussed a word called as non-justiciable. That means if in case it is not implemented, what you can't do, that means you can't go to the courts and ask them, because the courts will tell no, it's non-justiciable, but rights are not like that. Rights is an entitlement, so given to you. This was the very basic meaning. Fine. For obviously the very basic reason is what? Throughout the history, if you have seen, right from monarchy to feudalism to the colonial rules, any time, the people in power try to concentrate the power. When they try to, if they want to concentrate the power, obviously what they should do then? They should suppress the common man's right, common man's liberty. If you don't suppress, what will the common man do then? They'll revolt. That's the reason always those powers have tried to suppress the common man, all those things. Hence, the rights concept was not very important one. Of course, right from Aristotle to Plato, everybody have talked about it. That's not concern of polity, because we are, as I said, from mostly it is from our which perspective for us here? Indian constitution, what does it say? Fine. So what did Aristotle say? All those things largely is not our concern, of course. Then came, just to understand, you should understand the concept called as natural rights. Look at the name itself. Natural rights means what? Because there was a concept called as natural law also. Natural law means what? The idea is that the law that exists in the nature, those principles which exist in the nature, I don't have to give it, you don't have to give it. So what is human beings' role then? Just identify what is existing in in the nature in general and apply it. That was the natural law concept. From natural law comes this natural right. In simple words, again as I said, keep it simple for polity perspective, natural rights means those rights which which we get from the nature. Nature means in general we get it from there. Fine, nobody have to give it. King need not give it to us. Government need not give it to us, or the queen or the whatever the officers or the courts need not give it to us. Where is it existing? It's already existing in human nature. Fine, one is nature in general, and then there are also people who said it is actually not existing in nature in general. They say it is existing between humans in general itself. So we have to just identify. For example, a lot of people say we always, if you use your reason, you can identify that you should not hurt other ones. So hence not hurting other sentiments, all those angles they bring in. Fine. So hence by definition, what is natural rights then? Those rights which exist in nature in general, nobody has to give it to you. Another definition is what? Those rights which exist in humans by their in general nature. That is the point. Nobody has to give it to you. Again, so many people are there, but the most important person who's talked about it is a person called John Locke during French Revolution. Remember, we keep telling age of Renaissance, age of Enlightenment, which all happened in European, which led to French Revolution, all those things. John Locke says that there are three most important natural rights. One is called as right to life, second one is right to liberty, and third one is right to estate, or in simple words, let's make it as right to, which one? Property. This is according to John Locke, the three core natural rights. So without this, there is no meaning for human life as the idea. This is what later obviously led to, it was included in the, because the American Revolution was inspired by these kind of thinkers, they include even in the US Constitution also. Right, life, liberty, and the pursuit to happiness like that. That's all not necessary again. So this is the basic idea which emerged. Then another concept came, which is more evolved concept, which is called as what? Human rights, which is more specifically, if you trace the time frame, this is post Second World War. Now this is what? Again, as I said, it may have existed, the idea right from the Aristotle times, Socrates times and all those things, but in the modern times, what is the time frame? French Revolution means which century then? 1770s, 1780s, 18th century. This is post Second World War, means 20th century. In fact, a lot of people say this was most importantly because of the genocide of the Jews by the Hitler, Second World War. Because of that, a lot of people started to talk about this human right concept. Now look at the word human right. It is, in fact, a lot of people tell like this. This is natural right, and this is what? A lot of people say it is actually more or less the same also. Those are all very, very subjective terms. So basic idea is this. Then they use three keywords for human rights. By definition, human rights means what? Those rights that a human gets irrespective, or by the very simple reason that we all are born as human beings, you get it. Which country are you born? Are you born in US, Afghanistan, Uganda? Doesn't matter. Are you born as human being? If the answer is yes, you will get all these rights. Where? Doesn't matter for us. That is universal, inalienable, inseparable. They use three keywords. Universal means what? As the name itself says, means, just now I told you, everywhere, across the world, theoretically. Inalienable means what? Nobody can take it away from you. Inalienable, we can't snatch. That means, we in the sense, other person also can't take it away from you. More importantly, government also cannot take it away from you. Inseparable, or you can say the word indivisible, means what? They can't give this right in parts. They have to give it to you in complete. Fine. Freedom of speech and expression means they can't tell you, you do whatever you want to, but religion I will tell you to follow. They can't say that. Got it? So religion is also broadly part of your expression, part of your life. How can they tell that only religion aspect I will tell you which you have to follow, other things, your profession, your school, college, what you should write, what you should read, that you decide on your own, that's not allowed. You have to give it as a whole, complete. Got it? That is indivisible, universal, inalienable. But these are all concepts in theory. In practice it is not so easy because a lot of changes have happened. Now again what they do is, they have identified various generations of rights. Generations means what? Like how you have in mobile, the same concept. It will keep on evolving. Fine. The most important document is, okay, before this I will tell you there is a concept called as Trinity of Rights. Trinity means, as the name itself says, three important documents. Trinity of human rights also you can say. One is UN, Universal Declaration of Human Rights, which year? 1948. UN, Universal Declaration of Human Rights. Second one is ICCPR, International Covenant on Civil Political Rights. ICESCR. The word is called as covenant. Covenant means it's a legal document. International Covenant on Civil Political Rights. Remember yesterday we all discussed all these things in preamble. Political rights means what kind of a one? Right to vote, contest elections, participate in government activities, criticize them. Those are all freedom of speech and expression. Those things political. Civil means what? No discrimination. Social one, no discrimination. Untouchability should not be there. So those equality, everybody treated, those are all civil. Then emerged ICESCR, economic, social, cultural. That means what? Even your religion, your culture. Economic means what? Means what? Let's say very simple one. That is what in a way we call it as first generation, second generation, third generation, fourth and fifth. Today we are in fourth and fifth generation rights. First generation rights is nothing but what I just now told you. In the earlier stage we focused only on civil and political rights. Then we realized, very simple one, like remember we keep telling in your democracy concept, let's say you have freedom of religion, let's say you have freedom of expression, everything. What if you don't have basic job? What if you don't have, what are you not able to get basic minimum wages? What will you do using all those things then? What if you don't have health care? What if you don't have education, food, sanitation, drinking water? What is the use of religion then? What is the use of your freedom of speech and expression? I'll go express my. How do you express yourself if you are even struggling for 3 meals a day? That's when they came up with the concept called economic rights, social rights, cultural rights, which includes whatever I told you now. Economic covenant one. That is second generation evolved. Then another concept evolved, which is broadly we call it as concept of. Because remember, whenever we talk about the concept of rights, mostly by definition we are talking about everybody will get as an individual. I will get as an individual. You will get that as an individual. You will get that as an individual. But later a concept emerged. Even we as a group may get certain rights. Group as a whole. For example, that's when the very famous concept during Second World War itself or post Second World War decolonization process, rights to. This is a very famous collective right. Means what? Right to self-determination. Means let the people decide who should rule them. Like let's say we as a whole decide which party rules us. We as a whole will decide which country we may belong to. We as a whole will decide which ideology we have to follow. That is in a way largely right to self-determination or rights of minorities as a group. Remember even in Indian constitution we discussed that as a minority, as a group, as a collective have the right to conserve their culture, have their right to establish their own minority educational institution. That is right to self-determination as a group. That's why what is it? Collective right. But first two rights mostly were what kind of a one? Individual. As an individual I will get it, as an individual you will get it. This is as a group. Minority as a group will get it. Refugees as a group will get it. Migrants as a group will get it. Or people of country as a whole may get it. Or women may get it as a group. Got it? So our children will as a whole get it. That is called as right to group rights. Collective rights. These three are clear because clear in the sense UN has already given official documents, hence the concept is clear. Legitimizing. Because UN if releases it, it's a official document like Government of India document just say. But the fourth and fifth generation rights are still evolving. A lot of people tell this is also fourth, but a lot of people tell this is fifth. So it is still no clarity on fourth and fifth, but I will give you a brief idea. Fifth generation means fourth generation means a lot of people are telling they are what kind of rights? Future rights. That means what? Here you are all talking about people who are born Right? We are born, hence we get these rights. Fourth generation is talking about what? People who will be born in the future. For example, sustainable development concept. Remember the sustainable environment, they would have told, use resources in such a way that you meet your needs, but how should you do it? That the needs of the future generation is also not compromised. That is, you are talking about the future people who will be born in the future, not yet born as human beings. That concept, a lot of people are calling it as fourth generation rights. There are a lot of people who are talking about fifth generation rights also, which is mostly the digital rights and rights of the, see here again you are talking about human beings. There people will be born in the future as humans. Then a lot of people are talking, there are also those concepts which if we want to survive, we need a lot of other things. For example, river Ganga and Yamuna was declared as a living entity. That Ganga and Yamuna itself will how will Ganga and Yamuna will have right? As we may consider it as that it has life, but by scientifically it doesn't have right, what life, but it is given. Legally it has the right. That means river Ganga and Yamuna is considered as a living entity. It has a right to be unpolluted. Now it can't clean itself, so then it is the responsibility of whom? The governments to make sure that the river is unpolluted. That is called as rights of the non-living entities or non-human beings. They are not human beings, but they will also get rights. Those are all, that's why, what is it? Evolving, fifth generation rights. Remember, even recently Supreme Court had said a right called as, have you heard this? Right to be, what? Right to be forgotten. That means what? Not like you forgetting yourself. Right to be forgotten in the sense, let's say for example, I mean recently the case was, I think it was related to some doctor or someone, but I don't remember the exact case, but I'll tell you the previous one. It was related to a person called as Kaushik, who was Abhishek Kaushik or Abhilash Kaushik, who was some kind Bollywood Hindi actor who did not succeed, whatever the issue is. Now there was a accident related, drink and drive accident related case related to him in 2010, 11, whatever, some 10, 12 years back. Case was registered against him. Obviously media would have covered it, you will find the information on internet and everything. Fine. Now he has given up everything and he is trying for job or something. Now even if you search his name, he says his drink and drive related issues still come on the media, I mean internet. But the court has already acquitted him. That means what has the court told? The courts have already told he is not involved in this case. He is free. He is not guilty. Now that person has gone to the courts and said, see, my child is getting to know that I was involved in so and so issue. Even though if I am not involved, the internet forums still carry that I am still involved in that. So it is affecting my reputation. It is affecting my privacy. My dignity it is affecting. They went to the court. And the courts told whatever information related to him like that, the internet search engines, Google, this, that, whatever you call him as, Facebook, everybody has to take that information out. There was also another case, I think it was related to some doctor or someone, some engineer or someone. When he had come here, I think some case related to him, related to drugs or something was there, NDPS, narcotic drugs one. Now he is living in US. Now whenever he applies to job in US, he says, he had put a case in, I think Calcutta, Calcutta High Court probably, says that even in US when someone searches about his name, the internet still says about what? That this person was involved in so and so drug case in India in so and so year. Now he went to the court saying, sir, courts have already declared me free. Why is this information still available? Because of this I am not getting job in US. My right to livelihood, my right to get a job is getting affected. Now he went to courts, courts have told, take that information out. It has to be deleted. So that's what you call it as, look at it. Right to be forgotten. Very simple case to understand more simply. For example, take Sushant Singh Rajput case. So imagine that Riya Chakraborty issue. So every person in the media, Arnab Chakraborty, before Sushant Singh died itself, he had confirmed that Riya Chakraborty herself had done it. He will not wait even for Sushant Singh Rajput to die. Before that itself, he will tell, yes, I know I am God and I know she will only do it, and he had declared it. Now that is technically called it as trial by media. Trial by media means what? Media itself is telling who is guilty, who is not. How will you tell? Who gave you the power to tell? Who is guilty or not? That the courts will tell. Why is the judiciary waiting then to studying IPC, CRPC and everything? That is trial by media concept. Now let us say, Sushant, this now after investigation, Narcotics Control Bureau, CBI, this, that, everything, nobody has found any proof. More or less everybody have told what? That it was mostly the suicide case, whatever the issue is, whatever pending, which stage you clarify that. Now if she goes to the court saying, so much of information is there available on internet which says I am the one responsible, this, that, everything, the courts may tell any information related to her, related to that case, delete. You have to delete. That is right to be forgotten. It is not so easy. For example, because as other individuals as a right also have the right to know. I have the right to know. You may go to the court saying right to be forgotten. But what do I have? I have the right to know. I should know, right, what has happened, what has not happened. Now this is a new issue which is coming up. Right to know or right to information of others, right to be forgotten of yourself. We need a balance. But that's why we are telling, this is what kind of right? It is still evolving. We still don't have clarity. There's a very famous document called as European Union's General Data Protection Regime, regulation, sorry. Under that, they have talked about right to be forgotten. In India, Supreme Court in case Puttaswamy case, right to privacy, we'll discuss all those things. Even in that case, Supreme Court told right to privacy includes right to be forgotten. But it is still evolving, no clear details are there. Getting the point? So these are all different generations of human rights. Yeah.
So can this be possible for someone who is convicted and completed his term?
No, that will depend on, the courts will not, just because you go, courts will not tell that, okay, delete the information. Court will, what will take? It will take so many things. Is the information necessary for larger public interest? Let's say, for example, you go and ask the information related to emergency, national emergency deleted. Courts will not agree. Public interest, government, people should have what? Right to know. Let's say you go and ask about the information related to Operation Blue Star deleted. Courts will not agree. Right to know. We as a citizen should know, right, what is the government doing? We as a citizen should know what happened in Sikh genocide. I mean, after Indira Gandhi, why Indira Gandhi, all those things we have the right to know, it can't be deleted. So many parameters will be there that all they'll judge. Finally, they'll give this. It's not so easy. Don't take it like just because you go put a case, they'll delete. Absolutely not like that. Got it? So these are all various issues emerging, digital surveillance issues. Fine. Now these are generations, but these are all what? Human generations, human rights. Now there emerged another concept. This is called as, look at the equation. What is the equation then? All the fundamental rights are what rights then? Constitutional rights. So because the constitution concept later gradually evolved, whichever is mentioned in your constitution, it becomes constitutional right. Now automatically then constitutional rights are same across the world or may change? May change, because what is the simple reason? Constitutions change. Whatever we mention in our constitution, what is the guarantee that the same will be mentioned in US constitution? Or whatever other, Canada constitution, France constitution. So constitutional rights vary. Automatically what will also vary? Because fundamental rights are mentioned where? In your constitution. Look at Indian part 3, article 12 to 35. Hence fundamental rights also vary across the world. But what doesn't vary? Human rights doesn't vary, because we wrote a word. What is human rights? Universal. Fundamental rights are not universal. Constitutional rights are not universal. Yeah, natural rights in general, it doesn't matter wherever you are, you get it. Fine. There is another concept which is called as legal rights. Legal rights means what? Those rights which we get as a result of the act passed by the legislature. That's why it is legal. For example, you have an act called as MG Narega Act. It's a scheme also, obviously. Under that you have, if you know what do you mean by MG Narega, look at the name, get the overall expansion of the scheme. Mahatma Gandhi Rural Employment Guarantee Act. Basically, you will get minimum 100 days of employment for a rural BPL family. So what is it then? Right to work. You have an act called as National Food Security Act. Under that you get, the name itself says, what do you get? Right to food. Basic one. Those are all legal rights because it is given by a law passed by the legislature. Again, is it common across the country, across the world then? Obviously no, because we may pass separate law, France may pass separate, Australia may pass separate. Understood? These are all broadly the concept of, this is just a basic idea. We still have to dig more in depth. Clear? Let's now write down few points. What is the only point you wrote? Till now, at least a broad idea, did you get it? Yeah. Now let's write this. Put the heading, natural rights. Sir, there is no privacy nowadays, although that all we'll discuss later. Natural rights. So put a small definition. Those rights which are those rights which are present in the nature, those rights which are present in the nature, irrespective of the state or in fact human being itself. Those rights which are derived from nature or present in nature, irrespective of the state or human nature. Sorry, or irrespective of the state, or you can say, humans also, irrespective of the state or humans. You can also write another definition. Those rights which are inherent in human nature. Some people call that as natural actually. Those rights which are inherent in human nature. Those rights which are inherent in the human nature. Fine. In the modern times, so who is a scholar? Write this. John Locke spoke about natural rights during French Revolution or in 18th century you can say. Not exactly French Revolution. John Locke spoke about natural rights, you can say, in the modern times. In the modern times, John Locke has spoken about. And what is the three core? According to him, the three important natural rights are according to him, three important natural rights are, so write that, copy. Three important natural rights are right to life, right to liberty, right to property. Clear? That is natural right concept. Then came a more sophisticated version, human rights. Human rights, it is derived from natural rights. So from natural law came natural rights, from natural rights came human rights. It is derived, it is a derivative of human rights, sorry, natural rights. It is derived from natural rights. And what is the time frame? It evolved during or post Second World War. It is derived from natural rights. It evolved during, or you can say post Second World War, in the backdrop of, it evolved post Second World War in the backdrop of genocide of the Jews by Hitler. Backdrop in the context of genocide of Jews by Hitler. Genocide of Jews by Hitler. Fine. Then, as I said, just write the keywords. They are, first one, that means kind of characteristic they are. They are, first one, universal. So, universal means what then? Yeah, okay, first let's, if you have space, above that you can define it also. Okay, below that itself we can mention. By definition, these rights are available to human beings. By definition, these rights are available to human beings. These rights are available to human beings. And what is the reason? By the virtue of being born as a human. By the virtue of being born as a human. By the virtue of being born as a human. Fine. Then define what do you mean by, that's why they keep telling it is inherent. Inherent means what? It's within you. So universal means what? Available to all individuals irrespective of the country. Available to all individuals irrespectively. So it means wherever you are born, your religion, this, that, anything, nothing matters. Available to all the individuals irrespectively. Then inalienable. It cannot be taken away by any, what you can say, state or power. Inalienable. It cannot be taken away by the state, government. It cannot be taken away by the state or government. Fine. Third, indivisible. Means what? It should be given as a whole, not in parts and pieces. Indivisible. It should be given as a whole, not in parts. Not in parts. Those are three core concept or feature of human rights. Then you write, copy this just like that. UNUDHR means what? United Nations Universal Declaration of Human Rights, the most important document related to human rights. That's why look at the time frame, 1948, post Second World War, 1944, 48. So C means International Covenant. Covenant means take it as legal document. On CPR means what there? Civil political rights. You just write the name here, details will write in the next slide. So ESCR means economic, social, cultural.
So what was ICCPR?
Huh?
What was the second one?
ICCPR, International Covenant,
On political rights.
Civil political. Economic, social, cultural. Sir, what are those examples? We'll write. Just you first write this. Clear? Then come back to this. Put the heading. generations of human rights. First generation. Don't write 1G then, write first generation human rights. First generation human rights. Reflected where? Matlab present where? Present in or reflected in ICCPR. Now you write the example. Mentioned or reflected in ICCPR. Example, right to equality. Right to equality. Right against discrimination, all kinds of discrimination. Right to equality. Right against discrimination. Right against discrimination. Freedom of speech and expression. Freedom of speech and expression. Freedom of speech and expression, etc. Of course, you can include religion also, freedom of religion also broadly. Religion is common, so many things it's common. Fine, that is few for ICCPR. Then ESC, second generation, write that. And what are the examples? Example, right to livelihood, work. Right to livelihood. Right to livelihood. Right to conserve or preserve their own culture. Right to conserve their culture. Right to education, health, food, etc. Right to education, health, food, etc. So those are all second. Third, collective rights, third generation. Collective rights. That means as a group we'll get it. Example, collective rights, example, right to self-determination. Right to self-determination. Self-determination. Or I can also add rights of minorities, migrants, etc. Rights of minorities, migrants, etc. Fine. So those are all group. Then fourth generation, rights of future generation, that is, or future rights. Rights of future generation, just write related to sustainable development. Rights of future generation related to sustainable development. Then fifth generation rights. Fifth generation rights. Rights of non-human entities, non-human beings. Rights of non-human entities. rights of non-human entities. Fine. Like, or for example, river Ganga and Yamuna are declared as, for example, river Ganga and Yamuna are declared as living entities by Uttarakhand High Court. River Ganga and Yamuna declared living entities by Uttarakhand High Court. By Uttarakhand High Court. In few years back, I think 2018 ka judgment tha ye. You can also write another one. It also includes, that is fifth generation. It also includes digital rights like, it also includes digital rights like right to be forgotten, right against digital surveillance, digital rights like rights to be forgotten, right against digital surveillance, right against digital surveillance. And those are all different kinds of rights. We still are starting. In fact, we have not yet started what is there in Constitution. Then write this picture, the illustration. Fine. So what is the equation? Then if you want, you can write that. Or below that, put the heading constitutional rights and let's define it. Constitutional rights. So as the name itself says, what is it? Those rights which are mentioned in the constitution of the country, fundamental law of the land. Constitutional rights, those rights which are mentioned those rights which are mentioned in the constitution of the country. Example, example you can write right to vote, right to vote, right to property are constitutional rights in India. That means they fall here. Right to vote, right to property fall here. What does it mean? They are constitutional rights, but what are they not? They are not fundamental. Let's say freedom of religion falls here. What is it then? Fundamental rights plus, yeah, right to vote, right to property are constitutional rights in India. It may be something else in US. In US it is a fundamental right, right to property, but in India it's different. Clear? That is constitutional rights. Then below, fundamental rights. Fundamental rights. Those rights which are mentioned in fundamental law of the land. What is the fundamental mother law of the land? Obviously, Constitution. Those rights which are mentioned in fundamental law of the land. Those rights which are mentioned in fundamental law of the land. Fundamental law of the land, that is Constitution, and also you can write, these rights are fundamental for the development of individual's personality. These rights, fundamental rights, are necessary, crucial for the development of individual personality. These rights are necessary for the development of individual personality. Fine. And in Indian Constitution, where is it mentioned then? In Indian Constitution, it is mentioned in Part 3. In some other, it may be mentioned, that's left to them. in Indian Constitution, it is mentioned in part 3. Of course, so many are there, we don't even have to write because that itself is the entire chapter. Then the last right, legal rights. Legal rights. Fine, as the name itself says, what is it? Those rights which are given by an act passed by the legislature. Those rights which are given by an act passed by legislature. Given by an act passed by the legislature. Fine, write the examples. You can write both. Like again, obviously, so if the statement says constitutional, legal as well as fundamental, all of them what? Vary across the countries. All of them, CR, FR, LR. Reason I have told you. So just write 2 examples. There are many, but just as of now, RTI Act gives you right to information. Like that, many are there, but just write 2. Now, if you have done, now put the heading features of fundamental rights. Features of fundamental rights. Features of fundamental rights. So, let us write few points. First one, all of them are available to the Indian citizens. This is feature of fundamental rights, means in Indian context obviously. All of them are available to Indian citizens. But few of them are not available to foreigners. That means even for foreigners fundamental rights are there, but few are not there. All of them are available to Indian citizens, but only few are not available, any which way you can write. But few are not available to foreigners. Few are not available to the foreigners. Example, just write the list, we will not discuss because that anyhow we will get discussed later. Article 15, 16, Article 15, 16, 15, 16, 19, 29, 30. Are not available to foreigners. That means they are not. That means, sir, what about another article, sir? That means it is available for them also. Only these are not available to them. That is first point. Second point, which like what we wrote for liberty, fundamental rights are not absolute. That means what are they then? What are the words we used? Qualified in nature. Fundamental rights are not absolute. Fundamental rights are not absolute, they are qualified in nature. Qualified in nature. So what do you mean by qualified then? Yeah, right there. It can be subjected to reasonable restrictions. That's why we are not just using the word restriction, we are using the word reasonable. It can be subjected to reasonable restrictions. Now, who will tell which is reasonable, which is not? The courts will tell, always keep that in mind. It can be subjected to reasonable restriction. Then 3. Fundamental rights are not absolute. Sorry, that we have written, right? Fundamental rights are not permanent. Fundamental rights are not permanent or they are not permanent or sacrosanct. Sacrosanct means what? It is derived or it is related to the word called sacred. Fundamental rights are not permanent or sacrosanct, sacred. So that means automatically if it is not permanent means what? Hence it can be changed, it can be amended. Hence it can be amended by amending Constitution under Article 368. Hence it can be amended by or through constitutional amendments. It can be amended by constitutional amendment under U/A, under Article 368. Under Article 368. Fine, that is not permanent or sacrosanct. You can change it for a very simple one. If you want, you can write, for example, in the original Constitution, in the 1950 Constitution, in the original Constitution, right to property was a fundamental right. But now where did we write it as an example?
Legal right.
Constitutional and legal right. In the original Constitution, right to property was a fundamental right. Then 44th CA, Constitutional Amendment 1978. 44th Constitutional Amendment 1978 made it a constitutional right under 300 capital A. 44th Amendment 1978 made it a constitutional right under Article 300 capital A. Constitutional right under Article, fine, 44th Amendment 1978. That is one, you can change it. The next one, fundamental rights are negative in character. Again, I have already told you multiple times by now, what do you mean by negative? Restrictions, correct. They are negative in character. So tell, what does that mean? It puts restrictions on the activities, powers of the state. Fundamental rights are negative in character. That is, it puts restrictions on the activities of the state. Fine. You can also continue. Some of them also put restrictions on other individuals. Means, for example, untouchability is there. It is not just government should not do it. It is obviously what? We should not do it on others. It's like that. Some of them also puts restrictions on the activities of individuals. Some of them also puts restrictions on, for which among them we'll discuss, that's what is the entire chapter is about. Some of them also puts restrictions on the rights of, on the activities of others, other individuals. Puts restrictions on the activities of the other individuals. That is negative in character. Then, which is obvious, we have mentioned multiple times, they are justiciable. Means what then? I have already given you examples. If in case you have directed a movie and some government has banned it, what do you do then? Go to the court. That's what is justiciable. They are justiciable in nature. So tell, what do you mean by that? It means one can approach courts. They are justiciable. It means one can approach courts if in case, that is if it is violated. One can approach courts if it is violated. If it is violated. Okay, that is one. Then, according to Indian Constitution, or under the Indian Constitution, Supreme Court is considered as, under the Indian Constitution, Supreme Court is considered as what? Guarantor of fundamental. That means if nobody comes to your help, Supreme Court will always come to your help. according to the Indian Constitution, Supreme Court is considered as the guarantor of fundamental rights. Guarantor of the fundamental rights. So these are broadly the features. Then of course what happens during 31A, B, C, all those things we'll all discuss in detail. So till now, this is the first base, starting foundation. So any doubts please ask. Now we have to start with your Article 12, the first article. Broadly it's fine? If it is yes, then put the heading Article 12, definition of state for the purpose of part 3. Article 12. Article 12, definition of state. Definition of state for the purpose of part 3. Sir, what do you mean by this for the purpose? It's a very simple one. Remember, obviously we are talking about part 3. That's where you find fundamental rights. So when you say purpose of part 3 means, whenever you come across the word state in this chapter, this is the meaning of state. That's what you call it as definition of state for the purpose of part 3 of the Constitution. Clear? What do you mean by Article 12? That's why they mention that in first article of chapter 3 itself. So what does it include then? It includes A, first one. It includes first one, legislature and executive of the union government. That means you can challenge the actions of legislature as well as executive. Legislature and executive of union government. B, same thing, state government. Legislature and executive of the state government. Legislature and executive of the union government. Legislature and executive of the state government. C, local bodies. Local bodies means what? Panchayats, municipalities. C is local bodies. Local bodies. D, constitutional, statutory, executive. Remember all those bodies we have already mentioned. D is constitutional, statutory, executive bodies. Constitutional, statutory, executive bodies including PSUs. PSU means public sector undertaking, your ISRO, DRDO, BL, BHELs, including PSUs. So this is what was mentioned, what is mentioned even now in your Article 12. So whenever you come across the word state in Article Part 3 of the Constitution, take it as this. So if the statement says state should not violate so and so, that means who should not violate? None of them should violate your so and so rights. Got it? So that is the basic point. Now here what is left out then? You are only talking about so and so things. Sir, what if private sector discriminate against me? For example, let's say a very simple case. Let's say, as we keep telling, you have in most of the cities what they do, the collection of solid waste, everything is given as a contract to, for example, for some whatever companies they give it as a contract. Now let us say solid waste management, like remember morning they come to collect solid waste in every major city. When they come and say, oh you belong to this caste, I will not collect waste from you. Oh this is so and so locality, here this caste lives, this religion lives, here migrants live, I will not go and collect waste there. Can they say that? Can they say that? Why can't they say that? Because they are working for, they may be a private company, but they are working for whom? Government, because government has given you the contract. Fine, so hence private sector in general is not. Means in, for example, let us say if you go to a government, if you apply to a company for a job, fine. So now is there guarantee, is there a mandate that they should take you for the job? It's left to them. But let's say, sir, what if they make a discriminatory mark against you that no, I will not take you to job because you belong to so and so region, so and so religion. Can they do that? That is different because that falls under Article 15 discrimination. But can they reject me for the job saying no, I don't like your attitude, I need a different candidate. Can they say that? Anything they can say. You can't go to the courts against that. But if they discriminated against you, you can go. That's different. That will become discrimination. So those are the differences. For in simple words, private sector in general is not part of state. They don't have any of these obligations. But if the private sector is working with the government in any project, remember we keep telling famously called as, you might have heard this, public-private partnership projects, remember, to construct highways, metros, this, that, everything. There if you have any kind, if private sector is involved, they are also fall under the definition of state, they should also follow the same obligation. That's the point. Fine, so like that is the private sector one. But and then again, which organ have you left out there? You have written legislature, executive. That means can the judiciary discriminate then? Can the, let's say you go and file a case in the court. Can the court tell, no, you belong to so and so, I will not take up your case? Can they say that? Or let's say you apply to, there are a lot of clerical jobs, so and so officers' jobs pending in Supreme Court, High Court, District Courts. You apply for the job. Can the Supreme Court say, no, for us, only people belonging to so and so religion or caste I will employ in my court, others should not apply? Can the Supreme Court or High Court say that? That's what is the two questions, which is not exactly mentioned in Constitution. A clarity has already been given by Supreme Court. Got it? What is the first question then? Please put the heading there. Is private sector part of the state under Article 12? Is private sector part of state under Article 12? Is private sector part of state under Article 12? Clarify. According to Supreme Court, according to the Supreme Court, if the private sector is working according to Supreme Court, if the private sector is working with the state, with the government, according to the Supreme Court, if the private sector is working with the state, then it is also part of the state under Article 12. If the private sector is working with the state, then it is also part of the state under Article 12. Fine. However, clarify. However, private sector in general, that means if it is not working with the state, it is not. However, private sector in general is not part of the state. However, private sector in general is not part of the state. Fine. Example, private sector involved in PPP projects. Example, private sector involved in PPP projects. Involved in PPP project. You can also write a private company which has got a contract from government, or what your DMC, MCD, what do you call it as, municipal, anybody. Next one, a private company which has got a contract from, private company which has got contract from government to collect solid waste. I am just giving examples so that you understand it easily. A private company which has got a contract from the government to collect solid waste. Fine, there are differences. Now again another question is what? Is judiciary part of the state under Article 12? Is judiciary part of the state under Article 12? Judiciary part of the state under Article 12. Again clarify, same, according to Supreme Court, it is part of Article 12. Of course, then again judicial work, administrative work are there, but that's all not necessary for us. So write the case. According to Supreme Court, judiciary is part of the state under Article 12. Write the case Naresh versus State of Maharashtra. Even there is another case called as A.R. Anthule case. But there will be so many cases. We are not studying for law, it's not necessary. Naresh was a state of Maharashtra. Judiciary is also part of the state under Article 12. Clear? Now that is a basic point. Now comes your next article, Article 13. We are still not starting with fundamental rights. We are still defining the chapter. Then you have to start with that from Article 14. Article 13. Fine, tell what does that mean. It says that any law or part of the law, it says that Article 13 says that any law or part of the law, which violates a fundamental right, any law or part of the law which violates a fundamental right will be declared as unconstitutional. Which violates a fundamental right will be declared as unconstitutional to that extent. That means only that part will be declared. Will be declared as unconstitutional to that extent. Fine. Sir, what do you mean by this? First, let's understand, then let's write the other points. Now, you might have heard about a provision called as what was it related to? It is this, criminalization of homosexuality, Indian Penal Code section 377. In simple words, if two people belonging to the same sex are involved in the physical activity, then obviously they will be subject. Criminalization means what? You will be put behind bars, imprisoned, not penalty. Now obviously in the ancient era and all those things, if you take, in Indian context, actually there was a broader perception. You look at the Shiva concept itself. Shiva is considered as what? Ardhanadishwara. That means what? Half the body is typical one. Ardhanadishwara itself says. But with the Victorian ethics means when the British came to India and when Queen Victoria was there, that kind of her era of ethics is called as Victorian ethics. There, because of the impact of traditional Orthodox Christianity in Europe or in England, they had a polar dimension. Polar dimension means what? Only two. That is, there is only men, there is only, or male, female, that's it. Other genders, they feel that they are unnatural. So they are going against the nature. That kind of concept had emerged. Because they were ruling India, and who made IPC? IPC was made by British. IPC original, if you don't know the year, the original IPC is IPC 1860. Means obviously who did it? The British did it. They had included that because it is only male and female, if anybody else gets involved, what is it then? You will be punished. Criminalization of homosexuality. This provision it stayed just another 2-3 years back also it stayed. Imagine from 1860. But obviously with the emergence of the new kind of value system and everything, a lot of people challenged it. Now look at the provision. Delhi High Court in the NAS Foundation case, what is the problem with here? Section 377, so only declare that point number 377 as unconstitutional. Remember, look at the wordings here. Any law or part of the law which violates fundamental rights. So now which part of the law is violating fundamental right? Section only that is declared unconstitutional. Now again this was questioned in Supreme Court. Then because Delhi High Court ka judgment, where do you question? Obviously in Supreme Court. It became a judgment called as it was questioned by a person called Suresh Kumar Kaushal case. Now what did Supreme Court do? Look at the wordings. Recriminalize homosexuality, telling, why are you worrying about them so much? There are only very few of them. So, and whatever so many logics they used, and then they said arguments is different, we'll look at into the case. They recriminalized it, saying let it stay. Now what happened to 377 then? Brought back. It will come back into existence. Then again Supreme Court in another case called as, after few years, I think after 2-3 years probably, Navtej Singh Johar case. Again what happens? Look at the word. And they said, right to gender identity is part of your Article 21, right to live a dignified life. Fine, Navtej Singh Johar case, so now look at it. Now even today this stands. Navtej Singh Johar case. That means what is taken out then? Section 3, that too actually not even section 377. Under the section 377 there are some 3-4 points. If anybody is lawyer, so you ask them, they may tell you in detail. One of that point is related to homogeneity. This criminalization of only that point is taken out.
It broadly speaks about unnatural offences. Out of that, only the aspect of homosexuality.
Exactly. For example, there is also related to whatever, I will not talk about that. There are so many kinds of unnatural one they define. Let's not discuss about that here. Basic point. So this was taken out. Got it? Look at it. Now are you taking it out? Are you taking the entire IPC out here? So that's what is, look at the wordings now, Article 13. Look at the wordings. Any law or part of the law which violates fundamental right is declared unconstitutional only to that extent. And then of course, Article 13, you can describe it as there is a doctrine of course there is doctrine of eclipse also. Eclipse we will discuss later. We also call it as doctrine of severability. Severability means whichever part violates a fundamental right, take that, keep it out. It's like amputation. That is the concept of Article 13. Typically, Article 13 is talking about a provision called, which one? Judicial review, because judiciary has the power to review the actions of other two organs. Got it? The word judicial review is not mentioned in 13 because that was your last 2022 prelims, 2021 prelim statement. Constitution provides for judicial review. Provides means mentions. Constitution doesn't mention the term judicial review, but it is given implicit, explicit. I already told you that part. So just copy this below here. Whatever you have written, copy this. Fine, now the issue has been settled till here. Means what? Its homosexuality has only been decriminalized. Now the issue that has been brought up is what? Same-sex marriage. So that is also being discussed because in a lot of countries, in few countries like I think in South Korea. So okay, I think in Australia also they are talking about it. In some states of US they are I think in some state of US it is already legalized. So all those issues are starting now because values have changed. Fine, emergence you can say kind of expansion of the concept of rights. Got it? So decriminalize and then write that also. Right to gender identity is part of your 21. Fine. Now write this. Article 13 talks about doctrine of severability and the power of judicial review. Or Article 13 is about.
Sir, is it only a part of section 377?
Yes, correct. Part of IPC, part of 377. Article 13 talks about doctrine of severability and the power of judicial review. Doctrine of severability and the power of or on the provision of judicial review. But clarify here. However, Indian Constitution does not mention the term judicial review. That's what is last year they have mentioned actually the term provided also they have taken it as mentioned. However, Indian Constitution does not mention the term judicial review. Does not mention the term judicial review. Then what is it? It is implicit in the Constitution. Implicit means it's there, but the term is not mentioned. Because if you mention the term, then you have to clarify what does that mean. So, but what is it? It is inherently present. It is inherent in the Constitution. Again clarify below. Constitution provides this power, judicial review power for both Supreme Court and High Court. Constitution provides the power of judicial review. Constitution provides the power. Constitution provides the power of judicial review for both Supreme Court and High Courts. For both Supreme Court and High Courts. Clear? Now, remember you have written a word called as any law or part of the law. Now then what is the question then? What do you mean by law? Clarify that below. Definition of the term law for Article 13. Because for everything there has to be clarity in the, that's how the law functions. Definition of the term law under Article 13. So under Article 13 when you say law, it means it includes so and so. Definition of the term law under Article 13. It includes A. Permanent acts passed by the legislature like RTI Act, RTE Act, National Food Security Act. Permanent acts passed by legislature. Permanent acts passed by the legislature. That is A. B. Temporary acts or temporary legislations, that also you can tell. B is temporary legislations passed by executive. Temporary laws or temporary legislations passed by executive. Temporary legislations passed by executive. Example, you might have heard a word. What is it? Correct. Example, ordinances. Example, ordinances. Okay. 3 is delegated legislation, or you can write the 3 words here: delegated or subordinate or executive. So if they use any term, so don't get confused then. Delegated or subordinate. Subordinate means people below. Delegated or subordinate or executive legislation. We'll discuss that, right? Or executive legislation. What does that mean? Example, you might have heard that is called as rules. Rules, government orders, notifications, bylaws, so many are there, but government rules, not government rules, rules, government orders, notifications, etc. So they are all called as what? Delegated legislation. Fine. And D, non-legislative sources of law. That means that is also a law, but it is not made by legislature. Non-legislative. Look at the term non-legislative sources of law. Non-legislative sources of law. Example, conventions. That means something which is followed, but which you don't find it in law. Conventions, customs, like which is followed as a part of religions. Judicial pronouncement means judicial interpretations. Judicial pronouncement means what is the judiciary clarifications, all those things. Judicial pronouncements. That means what? If any of this violates a fundamental right, when you say any law or part of a law violates fundamental right, any law means what all? If any of them violates fundamental right, what you can do them? Unconstitutional. That means if any act passed by the legislature, if any rule made by them, if any ordinances, or if anything violates, like for example, very simple, you take Sabrimala case. In Sabrimala case, what is the provision? That women of so and so age, menstruation age, should not enter the temple. It was not mentioned in an act. The act had given the power to whom? Temple to make the rules. Temple had said, temple had a rule that it will not apply. Now temple rule, temple cannot make a rule. Temple doesn't have that power. It is under Article 26 they can do it. It's not a source of law. But it's a practice, custom. You understand, right? Custom one. Now in Narso Appamali case, Supreme Court has said even custom is also part of this. Even if that violates, it's gone. So that's why Supreme Court said what? In Sabrimala case, it said that so-and-so provision is violating women's, what do you call this, equality, their freedom of religion, their freedom of expression, taken out. Getting the point? So like that, personal law is also part of this customary. So first, under law, that means first one is clear. It is simple words, act passed by it. Let's say Government of India, Parliament has passed an act. If that act violates fundamental right, what will the Parliament, Supreme Court do? Unconstitutional. Let's say there is ordinance passed by President. We'll understand the differences later. That is violating fundamental right. That will also be what? Gone. Then third one is delegated or subordinate or executive. What do you mean by that? First you should understand. Normally how the acts are made is Parliament or legislature will make a broad act. Broad act means what? Major points they will discuss. Small details what they will do? Small details legislature cannot discuss each and every single detail. For simple acts, first point, MPs will not be in the session throughout the year. Will they sit in Parliament throughout the year? Obviously they don't. Maximum they may sit for 80-100 days. Even within that, how do you expect a parliamentarian, a normal MP who is a non-expert to read all and discuss all the details in the Parliament House? They can't do it. That's why what they do is the procedure is they will make a broad things. Details they will leave it to whom? Government bureaucrats, officers, that you take care of the details. That's the reason it is called as delegated legislation. Delegate means what? Transferring. So that means Parliament is transferring to whom here? Bureaucrats. Though that I have made a broad law, you add the details. That's why there is a very famous statement which says the legislature makes the skeleton, bureaucrats add the blood and the flesh. Finally what you will have? You will have a human being. So skeleton is the core. That who makes? Legislature makes. But what do you do using skeleton? Or what will you do only using blood and flesh then? So skeleton is made by legislature, blood and flesh, everything is given by the executive. So that is called as delegated legislation. That's why look at the three names I have given. Delegated, subordinate, because subordinate means who is subordinate here? The bureaucrats, subordinates, or executive. Executive, the name itself says, so they will make it. That's what you call it as rules. For example, Aadhaar Act is, where does it fall? Aadhaar Act. Aadhaar Act, where does it fall? It's an act, permanent law. Let's say you have Aadhaar rules, where does that fall? Delegated legislation. RTI Act, permanent law. RTI rules, Motor Vehicle Act, A. Motor Vehicle rules, got it? Disaster Management Act is different. COVID rules, lockdown 1, lockdown 2, unlockdown rules. Rules who will make it? Delegated legislation. So those are the points called as, what do you mean by delegated legislation? What do you mean by subordinate legislation? Everything. Now here again one point is left out. Put the heading, which is deliberately left out. Is constitutional amendment part of law under Article 13? Sir, what if a constitutional amendment violates fundamental rights, sir? That's the next one. Is constitutional amendment part of law under Article 13? Is constitutional amendment part of law under Article 13? Can clarify below. According to 24th Constitutional Amendment 1971 passed by Indira Gandhi, according to 24th Constitutional Amendment, (1971), Constitutional Amendment CA is not part of law under Article 13. Constitutional Amendment is not part of law under Article 13. Even today, it is what is mentioned in 24th Amendment. But then what happened? Clarify below. However, Supreme Court in Keshwananda Bharati case has said, Supreme Court in Keshwananda Bharati case, Supreme Court in Keshwananda Bharati case has said that even if a constitutional amendment violates a fundamental right, even if a constitutional amendment violates a fundamental right, which is part of basic structure, even if a constitutional amendment violates a fundamental right, which is part of basic structure, it can also be declared unconstitutional under Article 13. It can also be declared unconstitutional under Article 13. So that means automatically what is it then? Hence, CA is part of law under 13. Because if you not declare it as part of law, then how do you subject it to a judicial review then? Hence, constitutional amendment is part of law under 13. Constitutional amendment is part of law under Article 13. That one broadly the act will stand, but as of now Supreme Court has given much more clarity and said in general if it is violating a general fundamental right will not interfere, but if that fundamental right is part of basic structure, it's gone. So if the statement says, so what do you call as this constitutional amendment is part of law under 13, answer is yes. Clear? So that is the point. In simple words, take it like this. If you do anything which violates fundamental right, what will happen to them? Everything is gone. That is the point. Clear? Doctrine of severability, doctrine of judicial review. This is the first basic. So features, types of rights, first one, how did it evolve, then the features, then the 12, then Article 13. Now we have to go to the original, the details of the rights. Just put a broad heading, right to equality, Article 14 to Article 18. Rights to equality, Article 6 broad fundamental rights you have. Right to equality, Article 14 to Article 18. Under that, Article 14, first one. Under that, Article 14, equality before law and equal protection of law. Right to equality is the broader heading. Under that specifically, first one, Article 14, equality before law and equal protection of law. and equal protection of law. We'll discuss that.
Sir, if a constitutional amendment is not is attacking the fundamental right, then is it a part of law?
I mean, in general it is. If it is not attacking fundamental right, the act will stay. Nothing will happen to it.
And in general, constitutional amendment is law.
Is
constitutional law.
then, I mean, in general you can't say. You have to tell which article. Under Article 13 it is. Yes.
Whether it deals with FR or not.
Because an Article 13 only deals with issues related to fundamental rights. So it is only there. Every term, everywhere they may have different. Here, law means so and so, and constitutional amendment is part of law here. In simple words, even if a constitutional amendment violates fundamental right, what happens to it? That one is taken out. It will be gone. Got it? So like that, we are now starting the cases. So many cases you will get it. For example, I mean, a number of things are there. So leave it. So even remember yesterday or day before, Amrutpal Singh is arrested under National Security Act. So National Security Act deals with a concept called as preventive detention. Now, even if he has not done anything also, you can arrest him, assuming he can do something. That is the concept called as preventive detention, Article 22. All those things we need to bring in now. So till now, revise it. Let's take some 10 minutes break. Then we'll start with 14. Okay. So let's write it and then we'll discuss Article 14. It says that state shall not deny state shall not deny to any individual. Actually, if you look at Article 14, it is the only statement you have there. State shall not deny to any individual equality before law and equal protection of law. Shall not deny to any individual equality before law and equal protection of law. Now look at the wordings. State shall not deny to any individual. That means Article 14 applies against whom? State. And it is available to whom? The word is called as individual. Are we mentioning the word citizen there? So that means it applicable to whom? Clarify that. In margin you can clarify. Article 14 is applicable to, first point, it is applicable against the state. Please close the door. First point, Article 14 is applicable against state. And what is the next clarification? It is available to both citizens and foreigners. It is available to both citizens and foreigners. That means it's not available against the companies and all. For companies is available, that's a different issue. It is available to both individual, that is foreigner, in citizens as well as foreigners. Fine. Now tell what do you mean by put the heading below that? Equality before law. It is not mentioned in Constitution. The term is, what are the components? You don't have it there. We'll discuss it. What do you mean by equality before law? Fine. So write the point. We'll discuss that. The concept is derived from UK common law. The concept is derived from UK. It has a negative interpretation. Again, negative means what? What should not be done? The concept is derived from UK. It has negative interpretation. It has a negative interpretation. Negative interpretation. What do you mean by that? It includes A. It includes A. First one, absence of privileges. It includes first one, absence of privileges. Fine, we'll discuss that. B. No one is above the law. No one is above the law. C. Nobody should be subjected to different law in different courts of law. Nobody should be subjected to different laws. Nobody should be subjected to different laws in different courts of law. That means in different courts. Nobody should be subjected to different courts, different laws in different courts of law or in different courts. Fine. So look at it. That is the equality. That means they are indirectly telling what should not be done. What should not be done? Absence of privileges means what? So absence of, if you broadly take it, it means don't treat rich and poor differently, men and women differently, X religion, Y religion differently, king, officer differently, common man differently, or whatever, those things. And don't apply different laws to different people. For example, Hindus different law, Muslim different law, or blacks different law, whites different law, men different law. Those are all don't apply. Is what in simple, of course it's not so easy, actually it's a very in-depth concept, but for polity this is enough. So basic point, do not apply different laws to different people. And for example, if you have heard in modern India also, you might have heard a bill called as Ilbert Bill controversy. In Ilbert Bill, what was the controversy actually? Yeah, that if it is Europeans, you have to go to different courts. If it is Indians, you have to go to different courts. If it is Indians, punishment was strict. If it is others, I mean Europeans, less punishment. Same was segregation laws in US, same was apartheid law in South Africa also. If based on your race, different color, different punishment. Fine, that one should not be applied is what you call it as what? Equality before law. Got it? Again I am telling it is not so easy, because then you can question, sir, then what about king, sir? You told that king can do no wrong. Then why are you not applying the law to the king? All those things are there, but for polity we don't have to discuss in detail. Fine. This is the basic concept of equality before law. Got an idea? Then the same, what is the next word? Equal protection of law. Completely reverse the concept. Equal protection of law. Equal protection of law. Derived from US. Equal protection of law, it is derived from US. It has a positive interpretation. It is derived from US. It has positive, that means they will tell you what to do. It has positive interpretation. What does that mean? First one, equality of treatment. Equality of treatment for individuals in equality of treatment for the individuals in equal circumstances. Equality of treatment for the individuals in equal circumstances. We'll discuss that. 2. Similar application. Similar application of same law. Similar application of same law for people in similar circumstances. Similar application of the same law for the people in similar circumstances. For the people in similar circumstances. And see, only likes will be treated alike. Only likes. Likes in a sense, we'll discuss that, I'll tell you the examples. Only likes will be treated alike. Fine, these are the 3 principles under equality, equal protection of law. For example, let's say, now look at the case. Just to explain the concept, we'll take it. Let's assume a murder has happened. Fine. And person X and person Y, both are involved in the same murder. Now this person belongs to whatever, some religion, he belongs to Hinduism, he belongs to, let's say, Islam or Christianity, anything you apply. Now what law applies to them? Same law, because in India you have uniform criminal code. Criminal code means anybody commits a crime, it's same. Fine, so they are in similar circumstance. Why? What is a similar circumstance means? You are involved in which one? Murder, obviously same punishment should apply to you. Fine, but let us say for example, this person Y is, let us say X is an adult and Y is what? Juvenile. Juvenile means, take it as what? Under 18. Remember the very famous, in the same city almost 10 years back, exactly 10 years back I think, in December 2012 or something. So you all know that it's still clear in the, I mean very, very fresh in the memory. Nirbhaya case of I think 6 or 7 people totally were involved, but 6, whatever, one was juvenile, others were adults. Now what has happened to adults? All gone. So everybody has been eliminated, I mean death penalty. But what about the juvenile? Yes, because IPC itself will not apply to them at that time, because at that time the definition of juvenile was less than 18 years. So the law did not apply to him. He was sent to Juvenile Justice Act. I think he was sent to remand home. I don't know where is he, all those things, that's different issue. Basic point, the law did not apply to him. IPC law did not apply to him because the third point, look at it, what does it say? Only likes will be treated alike. Means like means what? Like in the sense, similar individuals only. For example, 5 people are there, the rest of the people, all of them are what? Adults, they are all likes. Likes means same kind of people. Juvenile is not a like. So apply different laws to different people is the point. Got it? That's what in a way we call it as, in a way there is a concept called as, you cannot apply same law in the same way to everybody. There are so many issues which may be which may be present. Hence, you can use reasonable classification. Means you can classify, categorize people into different things. You can apply different laws to different people also. But the overall reason, let's say look at the word, it has to be reasonable. And whatever you do, it has to be just. It has to be fair. It has to be non-arbitrary, and it has to be non-discriminatory. So just because you have the power, you can't apply different law to different people. There has to be some reason for it, some purpose for it, and it should be non-arbitrary, non-discriminatory. For very famous example, I'll tell you. There was a case called as case filed by Madhu Limaye. Madhu Limaye was a politician and all those things is there, that's not necessary. Madhu Limaye versus Superintendent of Tihar Jail. Superintendent Tihar Jail. I think when Madhu Limaye himself was put in jail, that kind of whatever. The basic point is, you know, Tihar Jail obviously again in the same city. So Tihar Jail obviously was done by British. And every jail, every prison will have its own manual. Manual in the sense, how will they treat the prisoners in that jail, they'll have a manual. Now in that manual what they had done was, because it was done by British, for the Europeans there was a better treatment. Because who had made the rules, who had established the jail? But if you are an Indian prisoner, you will have relatively harsh treatment. Harsh in the sense what? Access to what kind of rooms you have, what kind of sanitation facility, when do you get the food, how will the jailer treat you, those kind of a small ones. Now Madhu Limaye went to court saying, is this not discriminatory? How are you treating Indian prisoner and European prisoner differently? Is there a purpose for it? Okay, fine. If you treat women and men differently, understandable. Because different situations, it's fair enough at least. Let's say for example, if one of the women is a pregnant woman, understandable, fine. She has some special challenges will be there, fair enough, you treat differently. Let's say for example, a physically challenged is there, one of the person. Okay, you give some special provision, understandable. Here, what is the reason? Then Supreme Court said, take out all those things. So Indian and European prisoners should be treated what? Equally. So that is not because it was said that kind of provisions are all what? They are not just or fair, they are, what is it? Discriminatory. It has to be non-discriminatory. It was discriminatory. You are discriminating between Indian and European prisoners. You can't do it. So then it was discontinued. That's why reasonable classification only is allowed, not non-reasonable classification. Got it? Similarly, there is another word we use called as class legislation. So always understand, class legislation is not allowed. Class legislation means, in simple words, again, these are all law concepts. Basic points, if you are treating different people considering their background, for example, like segregation laws, apartheid laws, those are all kind of class legislations, not allowed because they are discriminatory. This is class legislation means always take it as what? Discriminatory, not allowed, because what does it violate? Violates Article 14. Violates Article 14. Reasonable classification allowed, because what is a reasonable classification? We have already mentioned it. So it is allowed. What is it not violate? Because I have already told you, even in the last chapter of preamble, you cannot treat everybody equally. Equity concept, you have to give certain special provision for someone, but your treatment all has to be this. If you are treating different people differently, you should meet these conditions. Got it? So that is the point. Then comes your rule of law concept, but okay, fine. Till here, did you understand broadly the idea? Now look at Nirbhaya case itself, you will get the point. Fine. Even for example, under law, there I think there are various provisions. Let's say, for example, a mentally challenged, retarded person commits a murder. Now the same law will not apply to them, because there is a concept called in law. Again, this I am only telling you so that you get an idea. We don't want all this for polity's sake. There is a concept called as mens rea in law. Mens rea means what? What they'll check is, do you have the intention to do an act? Do you know the consequences of what you are doing? Then only you will be punished for the act. Got it? That's called as mens rea. If you don't have mens rea, that's why so you can ask, sir, why, sir, just I think he was, that person was 17, whatever, some 2-3 months less than 18 years old. Sir, why are you treating him differently then? What, in 2-3 months he'll become mature? But that's how you have to put some or other point. Now the juvenile definition is reduced from 18 to which one? 16. So the intention, the idea is that under 18, the children doesn't have mens rea. That means what they don't know. The assumption is that they don't know the consequences of what they are doing. They don't have the intention to commit that, because cognitive developments have not happened is the assumption. Is it good or bad? That's a different issue.
Now the test is changed to whether the person has the necessary maturity to understand the actions that he is performing to.
I think more or less the same only. Whatever. So that
Instead of age being the criteria.
correct. Okay. So the point is, do you have the intention? Do you know the consequences, and can you think in your conscious mind? Yes, his answer means you will get the punishment. No, his answer means no. Let's say mentally retarded kind of a one. If they commit a murder, I think same law will not apply. Some less punishments will be there. Let's say, for example, a quarrel happens between two people, and then you push, and then someone goes, hits it, gone. You will not get the same punishment, because you have not planned it and doing it. Let's say you plan it and then do it. Different. Getting? Everything is murder only, sir. That law will not take like that.
Culpable homicide not.
Exactly. It all matters. Whatever. Under law, the basic point is what? Do you have the intention? Did you? I think you're getting the point. Deliberately did you plan it? Or did it happen just in accident? So all those things will be taken into account. That's why we are applying the concept broadly as reasonable classification. I'm just giving it so that you get a broad idea. For this, you don't have to need all these points. Yeah, equality, protection. Now you put the heading. Reasonable classification. Under that itself, under 14 only. Reasonable classification. Reasonable classification. What does that mean? Obviously, the name itself says. It means individuals can be categorized into different groups. It means individuals may be categorized into different groups and different laws may be applied to them. Individuals may be categorized into different groups. Categories, classified or categorized, whatever words you can use, they can be categorized into different groups and different laws may apply to them. Different laws may be applied to them. Fine, but write those words. However, the classification should be what? Write those keywords. However, the classification should be just, fair, non-arbitrary and non-discriminatory. Fine? Non-arbitrary, non-discriminatory. Now write the examples. For example, write this. Superintendent of Prisons, SP Prisons. Fine. So what is the point? Just tell what is the point. Here Indian and European prisoners were treated differently, which was here Indian and European prisoners were treated differently. Indian and European prisoners were treated differently. So obviously what does it violate then? Yeah, it was discontinued because it violated Article 14, because there was no purpose for it. It was discontinued as it violated Article 14. Whatever, there will be so many details. We are not studying case laws here, just for us to broadly understand. But what Nirbhaya you tell, that's also a kind of reasonable classification.
So when did this happen?
Madhulima was a politician in 70s, 80s, mostly that time.
When we have different marriage laws for different religions, that is a reasonable classification.
Yes, as of now, if it is still valid, that means it's a kind of reasonable one. Yes, that's the reason they are demanding for UCC, Uniform Civil Code. That we'll discuss. That is still Article 44, we'll discuss that, don't worry. Personal laws. Fine, yeah, write that. Below that, another example, juvenile involved in the Nirbhaya case was not subjected to IPC. Juvenile involved in Nirbhaya case, was not subjected to IPC. Which law applied to him? Juvenile Justice Care Act applied to him. Juvenile Justice Care Act. It was not subjected to IPC. Juvenile Justice Care Act applied to him. Fine, if you want in margin you write, at that time what is the definition, now what has it changed to, just for your broader understanding. At that time what is the definition? 18 is, now actually you can put a question, if it is all, because assuming these are all new concepts, you can put a question saying, sir, anyhow they have changed the definition to 16, now why can't we apply the law to him? Yeah, that is, we'll discuss, that is a concept called as no ex post facto law with respect to the criminal laws. Same point you remember, that we'll discuss it there, just to an extension. Fine. Yeah, so that time it was 18, so now what is the definition? Now it has been reduced to 16. Now it's reduced to 16. Then you write this. Class legislation is not allowed as it is discriminatory and violates Article 14. Class legislation is not allowed as it is discriminatory, violates Article 14. It is discriminatory and violates Article 14. Clear? Then put the heading here itself, rule of law. Again, rule of law, Constitution doesn't mention, because equality before law is part of it, we are talking about it. Rule of law. Rule of law. So write few points we'll discuss. Concept borrowed from UK. Concept is borrowed from UK. The concept is borrowed from UK. It was given by Professor A. V. Dicey, Albert V. Dicey. Concept is borrowed from UK. It was given by Professor A. V. Dicey, D-I-C-E-Y. It was given by Professor A. V. Dicey. Again, it includes three components, or just write it includes under that A. This was your 2021 ka prelims question also. It includes, first one, absence of arbitrary power. Absence of arbitrary. Absence of arbitrary power. Write the points we'll discuss. It means no person shall be punished or arrested, anything. It means no person shall be punished except for violation of the law. So only if you violate a law, you will be punished. No person shall be punished except for violation, breach of a law. Except for breach of a law, violation of a law. First component. Second component is equality before law. That anyhow we have discussed again. Second component, equality before law. Equality before law. And third component, constitution is the result of. Constitution is the result of fundamental rights as interpreted by the courts. Constitution is the result of fundamental rights as interpreted by the courts. In simple words, you get your fundamental rights based on what the courts say. Constitution is the result of fundamental rights as interpreted by the courts. Fine. Now look at the first point is what? You have got the word called as arbitrary. I have already told you multiple times, we keep using two words. One is called as discretionary, second one is arbitrary. Discretion means what? It's your discretion, means what? You take your call. It's left to you, you take your decision. That's called as discretion. Then what do you mean by arbitrary? If the discretionary is uncontrolled, misused, unguided, so then what it is become? Arbitrary. So that was your prelims question in 2021. So unguided or misused arbitrary discretionary power is violating which article? Which article are we discussing? Article 14. Fine, so that was the point. So write that, clarify in margin, because even after studying all these things also you may easily get confused because of that. Please write in margin. Uncontrolled or misused or unguided discretionary power is called arbitrary or arbitrary power. Uncontrolled, misused, unguided discretionary power is called arbitrary power. That means you can be anybody, you can't just, that means what? Let's say police, just because they have the powers under CRPC to arrest, can they come and just arrest you just like that? Obviously what? The basic point, you should have violated a law, only then they can come and, that's the point of absence of arbitrary power, which is a very, very broad one. Equality before law we have already discussed. And third one is what? The core point is you have to go to, does UK have, because which rule of law concept is borrowed from which country? UK. Core point you ask yourself, does the UK have written constitution? No. In the beginning go back to the basics. Fundamental rights means they are the rights which are mentioned in fundamental law of the land. And what is the fundamental law of the land? So do they have the written constitution? That means what they don't have then? They don't have a clear-cut list of fundamental rights also, because there is no clear-cut constitution itself. So hence that doesn't mean UK people don't have fundamental rights or they don't have the rights. They do have, but who is giving it? The courts will give it to you. So that's why we keep telling in UK, constitution is the result of fundamental rights as given by the courts. But in India, constitution is not the result. Constitution is what? Source, because what we have? We have a written constitution. That's why we are telling part 3, article 12 to article 35, constitution is giving it to you clearly. That's why in India only first and second component applies. Third doesn't apply to us. Write the reason there below. In UK, there is no written constitution. In UK, this is for the third component explanation I am giving, because in books if you look at it, you will not get it clarified. In UK there is no written constitution. Hence, there is no clear list of fundamental rights. In UK, there is no written constitution. Hence, what you don't have then? There is no clear list of fundamental rights. There is no clear list of fundamental rights. Hence, what is the point? Hence, constitution is not the source. Hence, constitution is not the source of FR. Constitution is not source of FR. What will happen in India? Next paragraph. However, India has a written constitution. However, India has a written constitution. India has a written constitution. Hence, constitution is the source of fundamental right. India has a written constitution. Hence, it is the source of fundamental rights. Hence, it is the source of fundamental rights. Now, that means what does not apply? Therefore, third component of rule of law does not apply to India. So, we only apply first two concepts. Therefore, third component of rule of law, third component of rule of law does not apply to India. Third component of rule of law does not apply to India. Fine. Then there is another concept, just clarify this, called as rule by law. Rule by law. It is more or less similar to your class legislation. Rule by law means what? So why are they talking about rule of law, everything? That means legislature should pass a law, there should be clear-cut rules and everybody should follow those laws and rules is the concept. Now the question is what? What if the law itself is discriminating? For example, during Hitler's regime, German legislature itself passed law, but those laws told that Jews and Christians cannot intermingle, they cannot marry, they cannot, whatever, so many things. Jews did not get so many rights, everything was taken out. Now, who is passing that laws? Legislature only passing it. Does it mean that it is all valid? Just because legislature pass a law, will it become constitutionally valid? It may be discriminatory also. So, those things are not allowed because what is it? It is ruled by law. That means it is discriminatory. Sometimes what will happen? Like in Indian context, there is no, to that level we don't discriminate. But in India also sometimes, for example, last year, last Chief Justice of India, Justice Ramana had told, unfortunately in India, rule by law also exists. Rule by law means what? Very simple. Let's say for example, same law is there. What if it is a rich and poor? How will the police apply to the law of both? We all know that, I don't have to explain again. That means, is the law different here? But what is different? The way it is applied is different. That is also what? So, that means two components. One, law itself may be discriminatory. Means Jews different, Christians different, like that, discrimination. Blacks, whites different, that is one of the point. Two, law per se is not discriminatory. But what is different? The way you are applying it to Hindus and Muslims, the way you are applying it to generals and whatever, the SC and all those, are the rich and poor, very simple one, is also broadly ruled by law. So that's the reason we should ensure rule of law and not rule by law. That was because Justice Ramana told last time, this concept again we are discussing. These are all actually again law concepts, which is not necessary in polity. When Chief Justices say you don't have an option, everything gets updated here. Got it? Yeah, so what do you mean by rule by law? Just tell. It includes those laws which are by itself discriminatory in nature. That means government is ruling in such way. It includes those laws which are by itself, that is per se, discriminatory in nature. It includes those laws which are by itself discriminatory in nature. by themselves per se discriminatory in nature. For example, during Hitler's rule, German legislature passed discriminatory laws against Jews. Example, during Hitler's rule, German legislature passed discriminatory laws against Jews. And that is one component. More or less your class legislation kind of one. What is the second component? Sometimes law may not be discriminatory. That is a very famous statement in administration, we call it as in public administration. Show me the man, I'll tell you the law. Means what? You tell me who is the person, I'll tell you how to apply it. So show me the man, I'll tell you the praise. Show me the man, I'll tell you the law, like that. Sometimes the law may not be discriminatory, but however, it will be implemented in favor of the rich and against poor. However, it may be implemented. Law may not be discriminatory, but it may be implemented in favor of rich and against the poor. And that is also kind of rule by law. So don't take it as rule of law, by law, everything is same. Both are obviously different. The goal is rule of law, rule by law violates 14. And if they say very simple statement, rule by law violates 14, yes, rule by law violates 14. Take that statement. In prelims they may directly give that. Rule by law violates 14. Class legislation violates 14. Reasonable classification doesn't violate 14. Clear? Now put the heading exemptions under Article 14 or exemptions for Article 14. Exemptions for Article 14, and then just copy this. Exemptions. That means a lot of points are there where different people may be treated differently also. What happened? Huh? So these are the immunities for the president and the governor. Official immunity is complete, and personal immunity again under that civil criminal cases, no proceedings against them when they are in office. Civil cases give 2 months prior notice before initiating the case. And then of course so many parliamentary privileges are there for MPs, that I will discuss when we discuss parliament chapter.
Sir, in India, rule of law and rule by law both work at the same time?
No. The goal, when they say both work, obviously not. You should tell rule of law is the goal. Rule by law is the criticism by few people, because in India we know how law applies to rich and poor and all those things. Hence, some people criticize that unfortunately we are still having rule by law. It's a criticism. Law does, I mean, in the constitution and all those things we don't tell rule by law. Criticism. Criticized.
Sir, then the idea, the concept of rule by law, it deals with the ethics of the law. Like
Yes.
law must not be made discriminatory. And if a law is being made discriminatory, and sometimes legislatures do, and it is being implemented, then we would say that this is rule by law is going on.
Yes.
Sometimes it happens in our country also.
Like how?
Some law is made such as there are very issues going around UAP. The way the laws are being amended, like this law is made in a wrong way, and it like without checking on the legality.
No, not like that. Let's say for example, if someone is arrested without committing, there is a concept called as preventive detention. UAPA, obviously Supreme Court, by UAPA is not a new act, it was done in 1967. So from then on it is existing, Unlawful Activities Prevention Act. Obviously it is not per se discriminatory. If that was the case, it would have been already declared as unconstitutional. But there are some criticisms against UAPA that sometimes police may arrest few people without doing preventive detention. Just on mere doubt, suspicion, they may arrest. That time you can criticize that you are applying it arbitrarily. Hence, it is a kind of rule by law. But by per se, law is not discriminatory because it has a larger purpose of national interest to prevent so and so security, so and so. By per se is not. Sometimes it is criticized. Like any law, it happens. For example, it is not just for this law. So many laws they criticize like that. Got it? In India, no law by definition is discriminatory. Because society is still evolving and human rights issues still need so much of corruption issues, everything is there. They may apply it favorably for a few, may not, but you can't help. You can't help in the sense we need reforms.
So such as still the police is catching people under section 66A of IT Act, although it is struck down.
Yes. Yeah, that kind of a one is, again, not by law discriminatory. The way you are applying it, exactly, correct. Like that multiple things are there. For example, if you don't know, as of now, according to the recent NCRB, National Crime Records Bureau fact, you have a concept called as, have you heard? There is a concept called as, what is it? Under trial. Under trial means you are in jail, but you are not at a convict. You are not at convict means what? There is a murder case pending against you, but the court has still not told that you are the murderer. You are an accused, you are not a convict. But you are still in jail because you are unable to get bail. Because not everybody can get bail, because for that so many conditions are there. That's why Chief Justice every time and again they keep telling we need bail reforms. If you want to get a bail under CRPC, conditions are there. You have to have a good lawyer, put some financial deposit, money deposit you should give. Someone on your behalf should convince the court that yes sir, if you are released, he will not harm anybody. All those whatever points is, and according to the recent NCRB data, you know how many people, if there are 100 people in jail, how many are under trials? How many may be? If 100 people are in jail, how many are under trials? Imagine. 80% just they are in jail. Cases are pending against you. Sir, why can't they come out? They can't come out so easily. Everybody will not be having access to all advocates and all those things so easily. And out of this 80%, another 80% is this is NCRB data and minorities. Sir, why only these things, sir? Sir, they'll commit more crimes, sir, let them. Not like that. So you don't speak in that kind of a political party's language then. So obviously because most of them will be what? Financially very, very weak. Socially they will not have that level of contacts. At least OBC relatively might be better now because conditions have changed. But these three communities largely, I am not telling every individual per se, last, let's say more than 2/3 still have those problems. That's the reason they are suffering. These are all loopholes in Indian laws, unfortunately. Clear? Out of how many people are still facing death penalty? One, I don't know exact numbers, you go through it. Out of that again, 80% are the same. That means if 100 people are given death penalty as of now, they're still staying. I mean, it might be they would have put a Percy petition, this, that. Even out of them, 80% are again belonging to the same. That means if 10 people are given death penalty, 8 people are these three. Why? Not because only they commit that kind of murders. The moment if you get a very, very good advocate, they'll argue in such a way, you can easily get some kind of bails or some kind of issues. But they will not get. It's not so easy. Because that's the reason there's a criticism that Indian judiciary is costly. You need very, very good advocates. Sir, but then the governments will provide bona fide pro bono lawyers, all those things. They may, but you generally think, what kind of lawyers will you get pro bono? So let the advocates take up. If that was such a situation, so why will you have so many problems then? If everybody works for free, you can't work, everybody can't work for free. So like that, so many problems are there. That's why we keep telling we need legal reforms, we need police reform, we need prison reform, judicial reform. Those are all broader issues, those are all main topic, we'll come to that. And at least note down these facts, these are very important facts, write in margin somewhere. First tell what do you mean by, sir please tell me about 21, you can't directly go to 21, it's a process, just please wait. Apply the Nirbhaya case, that's what you call it as, only likes will be treated alike. All the 4 adults are likes, hence they are treated same. Juvenile is not a like, that means this is different category, adult is different category, juvenile is different, hence different law. So under trial first define, what do you mean by, because these are all new, what do you mean by under trial then? Yeah, people who are in jail but still not convicted. Those people who are in jail but not yet convicted. And then write this, according to NCRB, Prison Statistics of India, the recent report, 80% of the people in jails are under trials. And 80% of them are backward class, SC, ST and minority. Fine, did you copy this? Now look at it. What do you mean by official immunity, sir? Let's say for example, recently, the Telangana case, if you have a newspaper, if you have followed every day, so time and again, have you heard anything about Telangana governor, Supreme Court and all those things? So Telangana governor has not given signature to almost around 10 bills passed by Telangana Assembly from September or October, let's say around 4 or 5 months. Now, can the Supreme Court, even if they put, can the Supreme Court call the Tamil Nadu governor, punish her? You cannot do that. Because they'll have what? Her decision you may question, you can't question her. You can't put her to jail or her, that is not allowed. Her decision only can be questioned. That is called as official immunity. This is deriving from the statement called as, what same? King can do no wrong. So there, president means there who? Monarch. King can do no wrong. You can't question them. Entire one actually is based on that. Now let us say a person X is president of India or governor of a state. Now let's say there is a criminal case pending against them. That should just keep pending. Means what? When the person is governor or president, you cannot start criminal cases against them. Sir, there is already pending. It is pending only. It will stay there. That is the point. No proceedings against them when they are in office. Sir, what if they are not president now? What if they are not governor now? Oh, he's a common man, apply. Sir, but he is a minister, doesn't matter. Because this applies only to whom? President and governor, nominal heads, dignitaries. If you're a minister, prime minister, chief minister, that's different. President and governor is different. Nominal head of the state. Fine, king can do no wrong principle. Sir, what if it is a civil case? That means governor and his brother has a property case against them. You can, but what do you have to do? If you want to initiate case against them, give 2 months prior notice. If you want to do it today, start the case related to them. Tell them 2 months before saying that so and so issue is going on, I am giving you 2 months prior notice. Please, whatever it is, if you want to settle it outside or whatever the issues is, please respond back. For others they may not give, for us they will not give 2 months notice, for them 2 months notice. That's what king can do. No, the very simple reason is, one, it is derived from UK, two, they are all dignitary positions, constitutional head of the state, and the image is symbolic position is that if such people enters the court, that means what? You will lose dignity of the position. You may start doubting president and governor itself. Then the overall dignity of office will come down. To maintain the dignity, they have done this. Ministers you may just remove just like that. Governor and president are not like that. Like that. One is UK legacy, second is this. Fine. And it's not so easy. Next one also you have. You write it. Next one. Foreign sovereigns and diplomats. Foreign sovereigns. Sovereign means ruler, kings. Sir, please explain equal protection of law. I think you joined late, Hanvesh. Please go back and refer. I have explained it multiple times now. Sir, who gave 2 months to them? It is mentioned in the constitution. Sir, right to privacy. It is part of your article 21. Please wait, don't worry. It's all one article after the other. You can't directly jump to article 21. Please wait. Fine, for sovereigns and diplomats. No, you can ask them. Of course, that restrictions might be there. But just because they have not given the signature, you can't call them to court. Those things are not. Yeah, now if in case, as of now, normally Supreme Court will not get into all those things. They may make broader rules and you have to follow to that. We'll see how the case goes on. According to the constitution, there is no time limit within which governor has to give signature to the bill. Hence, governor has told, there is no time limit, right? So I'll decide, why are you hurrying? Is what they have done, because ultimately it's politicization. But there is a broader concept called as constitutional morality. Means, look at the word, constitutional morality means what? You should function in such a way that you should abide by the core principles and values of the constitution. You should not hurt the values, the idea of the constitution itself. Everything cannot be written in act and rules. You should, what? You should function in such way. So we will see how the Supreme Court will act in that case. Fine, okay, now foreign sovereigns and diplomats will also get diplomatic immunity. Geneva Convention. Foreign sovereigns and diplomats will get immunity. So you write these cases, I'll just explain, you'll understand what does that mean. This is Majid Hassan Ashroor case, Jalil Abbas Jilani case. These are all cases to make you understand the point, or else what will happen, you will only remember it as a fact. Majid Hassan Ashroor case and Jalil Abbas Jilani case. So this Majid Hassan, obviously both happened in Delhi itself, because this is where you have all your other countries will have diplomats here only then. So Majid Hassan Ashroor was a Saudi Arabian diplomat. Take it as Saudi Arabian Foreign Service Officer in India. He was representing Saudi Arabia in India. And what was the case against him? The allegation was that he had sexually harassed a domestic worker, means a female working in his house. And again they found out that I think that female, that lady, I mean that girl was less than 18 years, child labor then. Child labor, domestic violence, sexual harassment, rape. But what was he? He was a Saudi Arabian Foreign Service Officer, means Saudi Arabian diplomat. So then what you can do? You can't do anything. He was sent back because they have diplomatic immunity. Same way, if you are an Indian Foreign Service Officer and if you are posted in other countries, If there are such kind of allegations, same thing. For example, if you have heard, yeah, Devyani Kobragade case, that also is the same. She was an Indian Foreign Service officer in US. Fine, she was employing, kind of domestic labor, but in US you have to pay per hour minimum wages. In India is what? In India we take domestic laborers for granted. So there you have to pay per hour, and she was not paying up to according to the US law. So that means you are violating labor laws. And she was also stopped. She was saying that you are violated in US, their law, why will Indian law apply to there? So that she was violating US laws. But again nothing happened, she came back. Saudi Arabia deployment, nothing happened, he went back. So what if you want to punish him? You have to work with the Saudi Arabian government and try to punish him under their law there. How will you force them? It's a loophole. That's why a lot of laws are there. It's not so easy. Jalil Abbas Jilani was a Pakistan Foreign Service officer again in Delhi only, and he was found out that he was tapping the telephone conversation of Indian politicians, Indian army, something like that. Tapping. Again, we can't do anything. You are violating law of the land because you can't tap just like that. But nothing happens. What that? Sent back. Fine. These are all deriving from, if you want broadly write it as Geneva Convention on Diplomatic Immunity. Even if you get into foreign service, you will also get that. Huh? Vienna or Geneva? Sure. Just someone search. Is it Geneva? Because now both two names normally will keep getting confused. Geneva is also there for so many immunities. Yeah, might be there because it's a.
Sir, what about the case of the famous Julian Assange?
Julian Assange is different one. Okay, but let me clarify this. Okay, so Julian Assange, if you have heard the WikiLeaks one, so US had cases against him. Fine, and he was staying in UK. US had cases against him. If you don't know the actual case, he was the WikiLeaks founder. I think WikiLeaks portal you still have. I don't know if it is still working or not. Whatever. So he was born in Australia. He was staying in UK. The case was registered by US. What is the case? He was releasing all those classified informations of how US Army is violating human rights in Iraq, in Afghanistan and all those things. So he released all those documents. Now what happened? UK agreed that we will extradite him to US. Because UK and US always have very close relationship. They said we'll extradite him. Extradite means you understand, right? We'll send him to US. Let them prosecute, whatever trial issues. Now what he did then? He took the asylum in Ecuador embassy. Ecuador is a country, Latin American country. Ecuador will have their own foreign service office, diplomat, like how you have consulate, embassy offices in London. Now he took asylum. Asylum means what? Kind of temporary protection. In simple words, he went and sat. Sat in the sense what? Not sat. He went and just resided in that Ecuador embassy. So let him reside. Let him reside means that particular area where the consulate is, geographically though it belongs to London, legally it belongs to Ecuador. In simple words, the London police or the England army, they cannot enter embassy of Ecuador. They just have to stay outside. He was staying within the Ecuador embassy for almost 7, 6 years, 8 years, whatever. House arrest. You cannot arrest him, he will stay there. According to the law, it is such a way that, let's say for example, Julian Assange is sitting in a car or whatever vehicle that belongs to Ecuador embassy. London police or UK authorities can stop the car. They cannot open the door of the car. Because the law says the property belonging to Ecuador embassy has nobody, they cannot be subjected to the law of UK. That also had happened. He was once sitting in that, just sit there. Nothing, they cannot open, you cannot move. That's the point. Recently, I think Ecuador embassy, the government, whatever changed, they took back the asylum. I think then what happened, I think he went to courts, whatever, I don't know the status now.
He's in the jail.
So whatever the points is, but is it Geneva or Vienna?
Vienna, 1961.
Vienna then, please make it Vienna. Vienna Convention 67. 61. 1961. This is just to get a broad idea. Fine, these are all the same issues. How the diplomats get the immunity. Sir, why is it? Because obviously you are staying in another country. Fine. So there is a threat to your life always. Let's imagine you are an Indian foreign servicer in Islamabad. India-Pakistan war is going on. Imagine the threat to your life. What if they take you hostage? So that's the reason they give all this kind of diplomatic immunity.
Sir, but in Devyani case, I think she got arrested by the American authorities. American authorities.
That's what, arrested in the sense, I don't know, arrested, it was actually not arrested probably, I mean you know the facts of the case, I think she was in airport, the immigration authorities stopped her probably to frisk. I don't think it was an arrest, whatever, the point is nothing will happen finally, you will be sent back, that's the core point. Okay, fine, the last one, this is all just to get a broad idea we are discussing. The last one under this, United Nations, United Nations and its agencies will also get immunity. That means the same kind of concept, immunities will also apply to them. UN and its agencies will also get same kind of immunity. UN and its agencies will also get, that means what, UNSC, UNGA, so many are there, all of them will also get the same kind of immunity. Fine, these are all related to Article 14 broadly, again a very important article. Now, or shall we continue? Article 15. Prohibition of discrimination on certain grounds. Article 15, prohibition of discrimination. Prohibition of discrimination on certain grounds. Fine, under that, Article 15, Clause 1. Clause 1 means you know, right? How to, I mean, just because it is in the beginning, I am just classifying. Point 1, subpoint 1, sorry, point 15, subpoint 1. Article 15, Clause 1. What does it say? State shall not discriminate. State, that's why they look at the word state, that means Article 15, Clause 1 applies only against state. State shall not discriminate against Indian citizens, or just write citizens, because 15 doesn't apply to foreigners. State shall not discriminate against the citizens on the grounds only of, shall not discriminate against the citizens on the grounds only of religion, on the grounds only of religion, race, caste, sex, place of birth. On the grounds only of religion, race, caste, sex, place of birth. That means only on these grounds, government should not discriminate against Indians. Fine, that is first point. Again, if you want, there shall be clarified. Therefore, what does it apply against? 15 Clause 1 applies only against state. Therefore, 15 Clause 1 applies only against state, and it applies only for whom? That we have already clarified in the beginning. 15, 16, 19, 29, 30, only for Indians, not for foreigners. 15 Clause 1 applies only against state. Fine. Then 2, there shall we clarify again. State can treat or state can discriminate Indians or citizens on other grounds. State can discriminate. Again, discriminate means what here? Positive discrimination we are talking about. Never the law will encourage negative. State can discriminate positively. State can discriminate positively few citizens on other grounds. Few citizens on other grounds. That means considering your poverty, considering so many other things, physical challenge, this, that, everything, they may give you special provisions. Positive discrimination allowed, point 1. Then 15 Clause 2. No citizen shall be subjected. No citizen shall be subjected to. No citizen shall be subjected to any No citizen shall be subjected to any disability. Shall be subjected to any disability or discrimination or liability, any words, shall be subjected to any disability or discrimination, same, on the grounds only of, religion, race, caste, sex, etc. On the grounds only of religion, race, caste, sex, place of birth, etc. But with respect to what? With respect to access to, that is entry to, with respect to entry to or access to hotels, restaurants, with respect to access to the hotels, restaurants, public roads, or in general roads, wells. Well means tank, water ponds, everything, anything, wells, and any other places of public character. And any other places, it can be house, it can be an apartment, it can be a mall, cinema, theatre, this, that, anything, any other places of public character, and any other places of the public character. Fine, this is actually a more broader one. Look at it. There 15 clause 1 only against state. Here again clarify. 15 clause 2 applies against both state and private individual. That means me, you also cannot do it. 15 clause 2 applies against. 15 clause 2 applies against both state and private individuals. Applies against both state and private individuals. Fine. So what are we talking about? Let's say, for example, you might have heard so many instances. Let's say, have you heard in modern India they might have told, called as, what is this, Mahat Satyagraha. There was a very significant historical event called as Mahad, M-A-H-A-D, Mahat Satyagraha. Mahad is a place in Maharashtra. So Mahat Satyagraha was related to obviously whom? Ambedkar. Now what is the point? Obviously during that time Dalits were not given access to the public wells in the villages. Well means you understand, right? The small ponds, lakes, whatever you call it as, where you fetch the water, all those things. At that time there was the only major source of water supply, everything. They were not allowed considering various historical whatever issues. Now what he did, obviously that is, at that time this constitution was not there. I am making you to understand the concept. Now he had gone there, fetched the water, and he had burned the Manusmriti and all those things. That's a historical event in Ambedkar's history, Ambedkar's career, whatever you call it as. Similarly, have you heard there was an event called as Vaikom Temple Entry Movement in Kerala? Vaikom Satyagraha we call it as Vaikom. It's a place in Kerala. Now what is the point? According to some facts, again some people deny it, some people take it, but basically in general obviously Dalits were not given entry to the temple. 2. According to few sources, the point was that, let's say for example the temple is here, the main Dwara, Mahad, whatever you call it as, the road leading to the temple, you are not given access to the entire road leading to the temple. Forget about the temple. Which one? If the road leads to the temple, you are not allowed to the road also. To that level discrimination was there. Now what is it violating? It's a discrimination. Fine. Now for example, let's say during whatever British time also, there were a lot of theatres which was only for British. Indians were not allowed in that theatre. Now can they say that, let's say you go to a mall, whatever this famous malls in whatever here, Inox is at anything, can they say that you belong to this religion, you are low, you are not, so you don't, can they say that then? Obviously no, because that is a public character. Let's say for example, it's your individual home. It's your individual home. Can you allow some person, can you not allow some person? Yes, because look at the wording, that's why what is it? Those places which are of public character. Let's say for example, whatever the huge builders you have across the country, builders are there, apartments are there. Now apartments means what? By the definition you are opening it to people, anybody can buy. Can the building owner say that, the apartment construction owner say that this is only for so and so, not for so and so? You cannot say that. These are all various cases actually. In Mumbai, I don't know how it works in Delhi. In Mumbai there are very famous gated communities. For every more or less caste, subcaste, they have a lot of these gated communities. So Jains one, the Parsis one, so within Brahmins, Maharashtra Brahmins one, so-and-so Brahmins one, Tamil Brahmins one, like that, so many are there. They'll only give to that community. There was a case involving an air pilot who had fought for India in the 1971 war. 1971 India-Bangladesh war, he had fought. Now in 1980s, he wanted to buy a flat. Now the person, the flat owner was ready to sell it. He was ready to buy it. But the apartment rules say, only so-and-so community is allowed to buy the flat here. Now he went to court saying, no, I am ready to buy. He is ready to sell. Now how can the community make the rules saying that you can't buy? Now the community argued that, sir, it is our cooperative society, we can make the rules under so-and-so act. Then they said, rule by law. Means what? You make your rules, we are not saying no, but what it should not be? You cannot discriminate just like that. Hence, gone, he was allowed to buy. Like that, many, even now a lot of created communities are like that. But if anything goes out of control, you have to go to the courts then. Those are all 15 clause 2. Whatever I told you, so many one, temple, cinema, theatre, apartment, this, that, everything is 15 clause 2. It's a very broad one. Related. That's why it is both against state as well as private individual. But remember the point, places of public character, not your individual homes and all then. That's your private space that's left to you. The moment you open it to public, let's say you are running a restaurant, can you deny access to few? That's all not allowed. Getting? Yeah, I think you got an idea. 15 clause 2. Huh?
So can we consider the telecommunication company
Telecommunication?
B, Vodafone Idea,
Huh.
as state because the government has a share in it?
Government has share in it. Then in that case, obviously yes. Yeah. But again, the definitions will be like the government should have the control, maybe they'll tell. That means you should have minimum 51%. That rule will apply then. Not a mere share will not apply then.
So any government aided
Government aided is different. There are a lot of rules for it. For example, there are government companies itself. Under PSU is a broader classification. That was your 2022 question also. Let's say one is departmental undertaking, like your Post and Telegraph, Ministry of Railways. Completely government will handle. There's another one called as public corporation. There's another one called as government company. But they are all broadly PSU. It will apply. Now let us say there is an NGO. NGO means you might have heard, right, in non-governmental organization. By definition, it is not created by government. But most of the NGOs may be substantially funded by the government. Means what? In simple words, substantially means what? Government is giving a lot of financial help to you. So then what are you then? You are definition of state. But it is just an NGO, sir. It is not dependent on government. You are not part of state. Sir, but it is a private company. 1% share government have. You are not part of the state. It is a private company working with the government in a project. For that purpose of the project, your state. What about the company in general? No. Let's say for example, TCS, Infosys, Wipro, everything you take. In general, what is it? It's not part of state. Lesser, but Wipro is working with the government in a particular project. Then for that purpose of the project, what are you? Part of state. Sir, what about other projects, sir? That's separate, that you leave it. Getting the point? So these are all so many things. You can't in general tell it. That's why those are all courts will clarify. But for us, you just understand broadly in polity. I tell you so that you get a broader idea, that's it. Yeah, I think broadly you got a point. What was I telling first of all? 15 clause 2. Now you put adding 15 exemptions and then write 15 clause 3. That means it is not so easy. There are a lot of exceptions for it. Exceptions. First one, 15 clause 3. Article 15 clause 3. Article 15 clause 3. State can provide special provisions for, or state can make special provisions for. State can make special provisions for the welfare of women and children. State can make special provisions for the welfare of women and children. That means, we obviously vulnerable sections, you can take special provision. You can't go to the courts and say, sir, why are you discriminating against men, sir? You can't go like that. because it's a special provision. Like what, sir? For example, fine, reservations for women in panchayat. That's a kind of special provision for women. Because I have already clarified all these points. Affirmative actions are not discriminations, they are positive discrimination. Example, reservation for women in panchayats. Then 15 clause 4. State can take special provisions. 15 clause 4. State can take special provisions. State can take special provisions for the benefit of socially, educationally backward class. It is not economically, educationally. SCBC they were normally called as. For the benefit of socially, educationally backward class, SC and ST. Benefit of socially, educationally backward class, SC, ST. Like what? For example, reservation doesn't fall here. In general, you can tell what? Scholarship benefits, fee reductions. Like even in UPSC itself, if you are a SC/ST category, you don't have to pay fee. Women also don't have to pay fee. Those are all the same. It is not discrimination then. I mean, it's just a 100 rupee fee, don't worry.
No, in all government exams, women don't have to pay anything.
So all those things are, I mean, that's the point I am telling. Fine. Scholarship benefits, fee reductions for whatever, OBC, SC, ST, all those things. For SCBC, SC, ST. That is 15 clause 4. 15 clause 5. Same point, a little more extension. 15 clause 5. State can provide reservation, so this is specifically reservation. State can provide reservation in educational institutions. That too professional education means what? Degree, not in the 10th PU, there it doesn't apply. State can provide reservation in professional educational institutions, including which one? Private institutions, including private reservations. Again, for whom? For SCBC. Now SCBC means you will understand. For SCBC, SC, ST. For SCBC, SC, ST. Fine. So reservations where? Reservations who is providing? Government is providing. In where? Professional educational institutions means undergraduate, above that. UG, PG, PhD is there. For whom? Socially, educationally backward class, SC, ST, including where? Including private university. You have so many private, even there it applies. In bracket, again clarify, except for minority educational institutions. So there it doesn't apply. That means Aligarh Muslim University, Jamia Millia University, St. Stephen's, Manipal institutions, no. Except in minority educational institutions. Yes, Article 30 provides them that special provisions. If you have seen, we will discuss that again in 30. There is a famous, St. Stephen's College in Delhi. St. Stephen's College case itself is there, wherein in that case, how much? Up to 50% of the seats in the St. Stephen's College can be reserved by the college for their own community. They may not give it to anybody else. Up to 50%. Of course, Christians, I mean, name itself says. So that for that. In Aligarh Muslim University, if you go to Jamia Millia Islam University, till now, I mean, as of now, because of Article 30, no OBC, no SC, no ST reservations. If they want to, they can get for women. That's left to them. But no OBC. I mean, you may get access to it. We are not saying no. But not reservation. Whatever some admission, something will be there. You clear the exam, you may belong to SC also, you will get it. But what you don't have there? Reservation is not there. That's what we are saying. Then don't tell, okay, that means only Muslims are not like that. There's so many people who have obviously, I mean, Aligarh is a very famous university also. But because it's a minority one, reservation is not there. That doesn't mean you can't get admitted there. Concept is you understand, right? Yeah. Except minority educational institution. Just example you write. Example, 27% reservation for OBCs. Central Universities Act. Or just, not necessary, basically understand 27% reservation for OBC. Fine, 27 for OBC, 16, 7, all those things are there. In general, those are all reservations, it's here itself. Fine, then 15 clause 6. Article 15 clause 6. State can provide reservation. This is the recent one, which is current affairs kind of a one also. 15 clause 6. State can provide reservation, obviously for whom? For the benefit of EWS, economically weaker sections. Here state means, don't take it as state government. Article 12 state. State can provide reservation for the benefit of EWS up to which one? Up to 10% maximum. Provide reservation for EWS up to 10%. Fine, same in professional educational institutions, except again same, everything copy paste. Up to 10% in professional educational institutions, including private institutions. Exactly copy paste the point, except minority. Professional educational institutions, including private institutions, except fine, except minority educational institution. Again mention, where was it added? It was added by 103rd Constitutional Amendment 2019, just before the 2019 Lok Sabha election. It was added by 103rd Constitutional Amendment 2019. And just 1 month back, Supreme Court has recently declared it constitutionally valid. Supreme Court has recently declared it. Supreme Court has recently declared it constitutionally valid. Supreme Court has recently declared it constitutionally valid in Janhit Abhiyan case. So this is a very recently famous one, because obviously constitutional bench, 5-judge bench. Constitutionally valid in which case? Janhit Abhiyan case. So underline the case, Janhit Abhiyan case. And a lot of people have this doubt also, clarify in margin. As of now, EWS reservation applies only in Government of India related issues. Means Government of India jobs, Government of India central universities. As of now, EWS reservation applies only in central jobs, that is government, central, what do you call this, central government jobs. Jobs will again discuss later, but only the point I am telling. EWS reservation applies only in the central government jobs and central universities, central colleges.
It doesn't apply to private institutions?
It applies. But you should be affiliated, right? There will be central, Delhi University might be there. There are so many colleges affiliated. Even there it will apply. But in general, central universities, that's the point. That means what about state universities, sir? It is left to the state governments to decide. It is not mandatory for them. If they want to, let them apply. If they don't want to, no. So wherever state you belong to, you question yourself, because it will vary. Most of states have still not applied it, because they have already applied it in the before itself. It's already gone to a state level. How much? 60-70% reservations are there. When you apply plus 10, where is the 80% it will go to then? Fine. So as of now, it is left to the state governments to take the call. These are all broadly the picture of Article 15. Got it? Yeah. So then comes your 16. So just put the heading, we'll discuss tomorrow. Article 16, because it's a very, very detailed one. Remember how many things we have to discuss under 16. Article 16, equality of opportunity in public employment. Look at the word public employment. That's why I have already clarified in previous classes. You don't have reservations where? Private sector. Article 16, equality of opportunity in public employment. There are 6 clauses. Will you write the 6 clauses and then we'll discuss tomorrow?
No.
Okay, any doubts still now? Please.
Exactly what Supreme Court said while validating EWS reservation.
No, we'll still discuss that. Tomorrow again, 16 class 6. But basically the question was, see, there is a landmark judgment, if you have called as Indra Sani judgment, which is famously called as Mandal case also, in which they are told there is maximum reservation is how much? 50%. In extraordinary, extreme cases, it may cross 50%. Now, because it is already 50%, now you are plus 10. So, how much is the reservation now? 60. Now, the first question that I put was, does this violate the Indra Sani judgment? First point. Because is it an extraordinary case or not? Second point, a lot of people argued, remember EWS reservation applies for non-OBC, non-SC, non-ST category. Means, let's say for example under OBC you have a concept called as creamy layer, you might have heard that. Few of you might be under OBC caste wise, but you may fall under creamy layer because economically you may be well off. So many parameters are there for that basically. Now a lot of people said, I will now go and get it under EWS also. You can't go get like that. If you are born as a OBC caste, you are not eligible for EWS. EWS is for, in simple words, Brahmin, Kshatriya, Vaishya, that kind of a caste only. Now that also was questioned in Supreme Court saying, sir, is this not discriminatory? Why are you not giving it for OBC and SC and ST also in that? That was another question. That's, for that people said, sir, it's violating equality, sir, it's violating basic structure. Another question which they questioned was, I think merit one, M. Nagaraj case was there, so related to that. So all these questions was there. So finally Supreme Court has said, first point, that Indra Sani case has told or put 50% for OBC plus SC plus ST reservation. This is Supreme Court's interpretation now. That 50% ceiling limit does not include whom? Non-OBC, non-SC, non-ST, hence valid, is a Supreme Court argument. Yeah, another question that was asked was, for the first time in Indian history, reservation is given based on economic parameter. Normally, remember SCBC I told, what is he there? Socially, educationally, not culturally backward, please don't use that word. That's a very, very subjective then. Socially, educationally backward. Now, first time you are giving reservation based on economic backwardness. That was also questioned. The reservation policy itself was questioned. And Supreme Court has said it is needed, and they have told the parameters for reservation has changed. Society has progressed. You also have to give it for others who are poor, and then they have given it. A lot of people question it even today. It's your subjectiveness. But because they have already given the judgment, you should just stick to it. Clear? Yeah, that is your 103rd constitutional amendment. Details are there tomorrow. What is reservation? How does it apply? Do you have reservation in promotion? How does it apply? There is a concept called as consequential seniority, catch-up rule. All those things broadly. M. Nagaraj case, Jarnail Singh case, many are there.
I have a question.
Please.
Sir, the generation of human rights that you talked about, sir, if we talk about the fourth generation of human rights, and that's the future generation's rights, so would the abortion rights be against those fourth generation of rights?
That is a very subjective question. Now, first of all, the question is, as of now, have you heard, see, this will go another 10 minutes, you can't help. I'll just give you a brief. See, in US there is a very famous case, if you have heard, I would have told you in some other article maybe.
1973.
The landmark Roe versus Wade case 1973, in which US Supreme Court had declared that right to abortion is a fundamental right. Means what? It's left to them, let them take the call. Why are you worrying? Was the point. Now recently this judgment has been reversed. Now in US Supreme Court they have told 50 years later, 2023 now, I think 2022 end may probably, they have told that it is no longer a fundamental right. Now the point is, in India as of now, right to abortion is not a fundamental right. Under MTP, Medical Termination of Pregnancy Act, if any doctor is there, you can clarify from them. Under Medical Termination of Pregnancy Act, you can get aborted. But there are conditions within 20 weeks, 24 weeks, about 24 weeks in so-and-so situations like that, many are there. Now the issue what comes up, first point is, there's an issue called as reproductive right of women. Means whoever female is carrying the fetus, she also has a right called as reproductive rights. Means I will take the point. Now, you can also argue from the fetus perspective. Does the fetus not have the right then? No, what is the issue comes up then? First you have to classify whether the fetus is human or not first. Now the human right definition is what? Those rights which you get by the virtue of being born as a human. Now the fetus is it already born as human or not? That we can't decide now. It's a legal question. Right? Born as a human being means, if you argue that, sir, fetus has also got life, but it is just within the womb means, that's another definition. No, sir, that doesn't matter. You have to come to the earth means, that's a different definition. Those are huge issues. So even you have to put a case in Supreme Court. That kind of question you asked, because it is reproductive rights versus the right of the fetus. Is the fetus human? That we have to see. But according to the case, Puttaswamy case of right to privacy in 2017. Right to abortion will become a fundamental right in future. Will it? Huh?
It is already a statutory right until 24 or 26 weeks, if I'm not.
That's what MTP, medical termination of pregnancy. But we are talking about fundamental. That one, is it part of right to privacy? According to case Puttaswamy case, all those things is part. But how effectively? That is not sure, because remember, values are still emerging. It's not so easy to take, because according to a lot of religion, the perspective is what? Only God can create life. Who are you to take someone's death? Is it suicide? Is it a kind of murder? That kind of question will come also. There are so many issues involved here. But then murder will apply to humans or fetus also.
Sir, but under IPC we have provisions against doctors who are not performing their duties in a right manner, resultantly harming the baby in the process.
Correct.
Section 299, if I'm not wrong.
Okay, no, that all I don't know, because IPC related one. Huh?
So in that there is a prescription of punishment of 3 years and
For the doctor who has not performed the duty
doctor
properly.
who is misperforming his duty.
Correct, agreed. That is related to the doctor perspective.
Then doesn't it mean that he is in the process harming the baby?
That's what I understand. I understood from that perspective. This is from the fundamental right perspective here. That means, can the women take that call first of all? Once you take the call, then that person, like for example, if there is a threat to the female who is carrying that fetus to her own life, then you can perform. That's a different issue. In general, can you take the call? It is reproductive right. I'm telling you issue, look at it. Reproductive right of the female versus right of the fetus versus the issue of, look at the religion angle. Because the religion angle is what? The belief is that only God will give the life. We are nobody to take is the religious perspective. And the kind of ethical perspective also. But will you apply it here? Because a lot of people argue, will the God come and take care of the child? Fine, so body autonomy, correct. Bodily autonomy concept is there. That's what, broadly reproductive rights. These are all issues which are still very kind of emotional and kind of awkward situations in India still. You can't discuss so openly. We have to see. It's not.
Any case going on regarding this?
I think they might have put it. But as of now, it's not a fundamental right, take it that. In US also it is reversed. That's what I can tell. How will it emerge? That we are all small people, that the Supreme Court will take care.